All right, we'll go back to that story in a bit, but for now, let's go back to the court.
Okay, thank you. All right, and now traverse the probation officer's reports concerning the personal circumstances of accused number 1. His wife is Maria Luisa Mthunzi, 54 years old, and the accused mother, 83 years old. Accused brother, 55 years old. Accused son, Sabelo Mthembeni Mthunzi, 31 years old, unemployed. Ketekani Eric Mthunzi, son, 28 years old, employed. Makunga Mthunzi, son, 25 years old, employed. Deto Mthunzi, son, 18 years old, student. And Yara Mthunzi, daughter, 16 years old, student. And Nobutula Mazibuko, sister-in-law, 37 years old. As a black man, I understand that we have what we call extended families. We don't live like pigeons or doves. So it doesn't surprise me if, for instance, the family composition of accused number 1 encompasses his mother, his brother, and a sister-in-law. Accused number 1 says he's a pensioner. When I was remarking that that amount of the pension was not disclosed to me, even here in the probation officer's report, it is not disclosed as I read this. But from the bar, Mr. Nobengula advised that the pension the accused is receiving is 25,000 rands per month. And he also has another independent stream of income. He says he supplies a business. That's an Uber taxi operator. and he makes a profit of about 15,000 rands a month. Let's see. But the way he operates this, he says, when he informs the probation officer, he also reported that he decided to buy a car and register it as an Uber meter taxi so that he can make an income. He reported that he is able to make a profit of approximately 15,000 rands a month. There's no indication that he plies this taxi like the usual taxi in the location where you honk your hooter the whole day, trying to attract business or passengers. Because a meter taxi, Uber, it operates differently. What he hasn't clarified is whether he himself drives that Uber taxi or not. But the fact of the matter is, he has an income of 25,000 plus 15,000, which is about 40,000. The only minor children which he has, who are scholars, students, it's the son, Mthembeni Mthunzi and Yaram Mthunzi. The two youngest children. He shares parental responsibilities, obviously, with his wife. The same remarks pertain to the fact that, obviously, if he's incarcerated, there will be a vacuum in terms of societal family relationships, because the patriarch of the family would not be around. But can one argue that with an income of 40,000 rands, this family will be so indigent that the impact, besides emotional and psychological, will also be financially untenable to such an extent that this family will be reduced to penury, as an Englishman would say? I doubt that. So in both instances, the financial means which the accused are in command of as pensioners with the South African police appear to be sufficient for a family of the social structure which is enunciated in both reports to make a living, not an extravagant living, but a living. Sorry. To reiterate then the guidelines, this court has established, as a matter of fact, that obviously if one of the parents is incarcerated, there will be an impact, as it is stated in the authorities. And this court has been able to consider the interest of the best interest of the child independently, not as an appendage to the primary giver's personal circumstances. It is so that if the accused is incarcerated, number one, the two children, if he assists them with their homework, they will miss his tutelage skills. But the court has got to balance the rights of the children with the other aspects as echoed in M versus S. The other question which the court has to deal with, it's the crisis the country finds itself in relating to COVID-19. The accused, rightfully so, contended that as over 60s, they have underlying diseases which are chronic. Diabetes, high blood pressure, and bodily pains of aging, pertaining to accused number 2, who has psychosomatic pains from his neck and back. If he's incarcerated, obviously, he still would need medication in custody. It is tried that in our jails, although they are bursting at the seams with people, there's medical attention available in jail. There are doctors and nurses in attendance. And relating to the COVID pandemic, we listened to the evidence of the director of the center, admission center at Johannesburg Prison. It's not as if once a person is over 60 or even below 60, he doesn't expose himself to, or he is not exposed to COVID-19 or 9. In the nature of things, in South Africa, everybody is liable, susceptible to be infected with the virus. You don't know where you'll find it. Even I, maybe, because I can't speak through this thick mask. Speaking like this, I may find it. But the question is, what do you do about it? In jail, it's not like it's a carte blanche situation where people are just headed in like animals. There's no medication, there's no screening, there's no testing, there's no social distancing, there's no washing of hands, there's no single cells. It's an ordered prison facility where the exigencies of COVID-19 pandemic are taken into account, like the gentleman director was telling us. You self-quarantine yourself, or you are quarantined, and if your condition needs medication, you are accorded medication, and if it needs ventilators, you are taken to a private outside facility, like the gentleman was describing. But fact of the matter is, we have to live with this virus. We lived through AIDS, which killed many, much more people than this virus, AIDS. And we survived it. I'm sure we will survive COVID also. The question is, if you take the necessary precautions, that's all you can do. Now the question is, it was argued, although not so clearly, that both accused are not candidates for custodial sentence. They've served their country for over 30 years as policemen, Mr. Lovengula actually emphasized that they are not even candidates for a custodial sentence. At worst, according to Mr. Lovengula, even Mr. Mthunzi, they must be given a suspended sentence. It would pain me if I must send the two accused to jail. It will pain me. I'm an old man also. I'm 73 years old, so I know what old age is about. They are relatively young, 62. In this court in Pretoria, we had the case of Bob Hewitt. The circumstances of the case were such that the presiding judge, Bam, reasoned that he was obliged to send a 75-year-old man to jail. Okay, that case concerned sexually abusing young girls when he was a tennis coach. It was taken on appeal, and the SCA upheld that sentence. The full bench of the SCA upheld that sentence. You just want to see this. Maya wrote the judgment. She referred also, as I'm doing, to mitigating factors, the advanced age of the accused, the ill health, and even the extraordinary lapse of time which inured before Bob Hewitt faced trial. But this is what the learned Judge Meyer says. But as the court rightly acknowledged, these mitigating factors must be considered against other relevant factors of the case. Scrupulous care must be taken not to overemphasize the appellant's personal circumstances without balancing those considerations properly against the very serious nature of the crimes committed, the aggravating circumstances, the consequences of the victims, and the interests of society. Much was made of someone standing in the community, and certainly the accused had a good and high standing in community, like the two accused before court. And much was made of the appellant's standing as a tennis icon who successfully represented his country internationally, and the impropriety of imprisoning such an individual because his fall from grace, like in this case, and the pain of the trial was in itself sufficient punishment. As he had already learned his lesson, but this submission overlooks the basic tenets of our Constitution, which decrees equality before the law. Our law knows no class distinction of offender of the proposed nature. The appellant's erstwhile celebrated status does not therefore earn him a special sentence. The appellant's poor health, which was also chronic, like in this case, certainly is a matter which must be considered, and so too is his advanced age, 75. He does not suffer from a terminal nor incapacitating illness. He leads an active life, and regarding his age, whilst courts have considered oldness as a mitigating factor, it certainly is not a bar to a sentence of imprisonment. When the appellant was finally brought to trial, he pleaded not guilty and maintained his innocence, even after his conviction, like in this case. Therefore, he had to testify in court. The complainants therefore had to testify in court and relieve the trauma of their ordeal. During mitigation of sentence, the appellant still showed no remorse for his vile deeds. The first complainant was referred to as a so-called rape victim. Like in this case, Alice Manana was called "this bitch must die." Told that she will talk. Whilst lack of remorse is not an aggravating circumstance, it would have rebounded to the appellant's favor if he had shown appreciation and contrition for the devastation he caused. Although the element of rehabilitation bears little relevance here because of the appellant's age, like in this case, the sentences would still serve the other important purpose of sentence, that is deterrence and retribution. The SCA also, in the case of Swart, R.S. versus Swart, Judge Nugent was also of the same view that the courts must exercise a balancing of all the sentencing factors: retribution, deterrent, rehabilitation, and preventative. But in this case, like when he says that in the case of Swart, retribution must come to the fore, as unfortunately I also am of the same view in this case, that this is one of those cases where, as Nugent says, that in our law, retribution and deterrence are proper purposes of punishment, and they must be accorded due weight in any sentence that is imposed. Each of the elements of punishment is not required to be accorded equal weight, but instead proper weight must be accorded to each according to the circumstances. Serious crimes will usually require the retribution and deterrence should come to the fore, and that the rehabilitation of the offender will consequently play a relatively smaller role. I've considered all the modes of sentences from Fagan in the 50s, 60s, saying the jails are bursting. And I've considered the custodial sentence, I've considered this. I've also considered a correctional service sentence, and even considered a victim compensation and a fine. But the circumstances of this case, because we're dealing with two senior policemen who abrogated to themselves powers which police normally have, but these powers were abused to such an extent that the effect was devastating on the victims, and consequently, in my view, the only appropriate sentence under the circumstances is a custodial sentence. Okay. Consequently, this court sentences you the following way. In the 2 counts of kidnapping, you are sentenced to 3 years imprisonment each. But these 2 counts, the sentence of 3 years in respect of each will go concurrently. That the duality of the sentence therefore means that for the kidnapping charges, you are to serve 3 years in custody. In respect of the 2 counts of assault, you are both sentenced to 1 year imprisonment.
Is it 1 year each?
Yeah, 1 year each imprisonment. But these 2 years are ordered to go concurrently with the 3 years of the kidnapping charges. And in respect of the 2 counts of assault GBH, they are both sentenced to 2 years imprisonment on each of these charges. Consequently, effectively you're sentenced to 5 years imprisonment. Okay. Is that the wrong?
The one for responsibility, you said it's 2 years each. Should they run concurrently, the 2 years each?
There are 2 counts. They run concurrently, meaning he's serving 2 years each
Yes.
for assault GBH. 2 years, 2 years. It's 4, but it's 2 years because it runs concurrently. And then the cumulative sentence is 5 years. Okay. Yeah. Okay, is that the role?
That's the role, Malu. I don't know whether my colleagues will address the board, but yes, that's the role.
Mr. Mdluli?
Yes, Malu, it was this
Okay.
but we have come back to my colleague, Mr. Barnett, that we would like to ask the court to set a bail amount in view of an application for you to appeal, which we have tentatively agreed on the 14th of October.
Why should I set a bail amount? Mr. Mdluli, I'm asking.
Yes, my lord. The accused before court have been on warning all along, and it is not release them.
Sorry.
If it is
Sorry. Sorry, Mr. JP. Yeah, you're saying?
Yes, I'm saying, my lord, that throughout the trial they have been on warning, and now that they have been convicted and sentenced, it is not competent for any court to
It's not competent for any court to?
to release them on warning. Bail amount is fixed if the court is inclined to do so.
Yes, Mr. Mthunzi.
Hello. I agree with that proposition. It's something that I have recently become aware of and quickly tried to research. And indeed, it appears that the authorities are saying that the picture is different after sentence. And if the court is inclined to release the accused, it can only be after fixing bail. And without speaking for my Leonard friend, there's a draft order agreed to by the parties, obviously subject to your lordship's blessing, where the amount has been said has been agreed to be 5,000 rand.
Okay, let's hear the state.
Accomplice, my lord. I understand that there is now an application by my learned colleagues for the accused or sentenced accused to be released on bail pending their application for appeal. And just indicated that previously they were on boarding. The state is now going to approach the application for bail being granted for the application appeal. It is indeed so that a draft order has been prepared by myself. Obviously, depending on the lordship's approval. I've also discussed certain bail conditions, also set out in the draft order. And if the date is suitable, my learned colleagues indicated that we should bring the formal application for leave to appeal. I don't know whether it's going to be against conviction and sentence or whether it's just going to be against one of either the conviction or the sentence. But be that as it may, if your lordship is amenable, the tentative date that has been arranged is the 14th of October 2020, if your lordship is available.
What does the law stipulate? I don't even want to get into that, but we all know the law. What does it stipulate? When do you get bail? What does the law stipulate?
My lord, as far as I have it, if one there's an application for leave to appeal, the court can consider it and then
After considering what?
the application for leave to appeal.
That's the point. That's the point. So there's no leave to appeal before me.
That's for
And I'm not inclined to grant bail without that. I'll be transgressing the law. The law specifically says there's got to be a leave to appeal before it, for it to consider. And thereafter it can make an adjudication. But you can't just make an adjudication. Okay, that application is declined. Okay.
Look, my lord, before the court adjourns, my lord, the arrangement that we came up with was based on the contingency that the application will only be done on the 14th. But otherwise, we are ready to bring the application now.
Yeah, fine.
Yes.
Fine, you can bring it.
For my client, I'm ready.
Fine. What do you say?
Well, you can proceed with the application.
And you, Mr. Lobegula?
The court, please, my lord, if we can just change the order, if Mr. Guru may start.
No, but you, when do you want to bring the application?
I would have to bring it now, but the order, if I may ask that Mr. Guru goes first.
Okay, fine, yeah. Let me just inquire from you. The application for leave to appeal, is it being opposed?
Definitely, my lord.
Okay, let's hear. Mr. Mthunzi, they say you must start.
Yes, I can start. My lord, before I start, let me indicate that I'm not going to ask for an opportunity to obtain instructions regarding the sentence that the Lordship has just given. And the reason being, I already hold instructions after that long session of yesterday, where your Lordship went about prefacing the sentence. Me and my client had an opportunity to consider the utterances already made by your Lordship. And your Lordship will recall that one of those utterances was already that the court was of the view yesterday that indeed the request by the state for custodial sentence is the only appropriate sentence. I therefore hold instructions that...
Because that's the utterance I said. I didn't say the state argued that the only appropriate sentence is a custodial sentence.
They said that,
Yeah, that's how I put it.
And unless I'm wrong, I think I heard your Lordship also saying that the Lordship was also was agreeing with that. But be that as it may, your Lordship, I then hold the instructions that apart from the indication already given regarding the intention to appeal the convictions, in case your Lordship was to impose a custodial sentence, I already hold instructions to also appeal.
Yes.
Apply for me to appeal that sentence. My Lord, having done that, I wish to refer to a judgment. I think the judgment by your brother Mushib in this division, where he makes the point that even an application for leave to appeal is being brought, the judge shouldn't be offended. The judge shouldn't like think it's an attack on either his integrity or credibility or his reasoning or understanding of the law. No. It's part of the process. Yes. So I would therefore, and I'm sure that I sound superfluous on this point, because the Lordship is fully aware that that cannot be dealt with as an affront to your Lordship. Now, my Lord, as far as the convictions are concerned, the point of departure is the following. Your Lordship has properly, in our view, found that these convictions, they are essentially based on the evidence of a single witness, namely Alice Manana. And they all happened on the same day. Now, what does the law say when if the court is to convict on the evidence of a single witness? My Lord, the law is clear. It says that the cautionary rule then kicks in. In other words, the court must apply caution if the court is to find or retain a verdict of guilt on the basis of the evidence of a single witness. And that's exactly what we're seeking. And my Lord, we submit with the greatest of respect that the Lordship has erred. Judges do err from time to time. Sometimes they err being fine in the Supreme Court of Appeal. Nothing strange there. We submit with respect that the Lordship has erred when it applies, when it comes to the application of the cautionary rule. That cautionary rule, we submit with respect. The Lordship has, as lawyers or legal parlance would ordinarily put it, the Lordship has merely paid lip service to the rule, but in terms of the application, in the humblest of ways, we submit that the Lordship has erred. Caution, as the courts and authorities have clearly stated, ordinarily, it comes by way of corroboration. The Lordship, we submit with respect that there is no corroboration in this matter. I have gone through the Lordship's judgment again, because it has always worried me that where was the corroboration? And I've seen how your Lordship has gone about to find what was called corroboration. And for an example, the Lordship has found corroboration from the statement of Governor regarding whether the assault charges were ever opened or not. But your Lordship, we submit with respect that the court has erred there. And in this respect, I wish to quote from your Lordship's judgment itself. My Lord, I think it's on page 71 up to page 73.
The sound not too perfect there, so we're going to move on. But Judge Ratama Kwateng finishing off his 2-day-long sentencing of Richard Mdluli and his co-accused Mthembeni Mthunzi, turning down a last-minute request for bail. The judge using words such as callous abuse of power and colleagues consenting to the whims of Mdluli and Mthunzi, and in the process committing dereliction of duty. So sentence of 3 years for kidnapping charges, 1 year for imprisonment for assault. These sentences will go concurrently, which means they will serve the 1 year within the 3 years, but also 2 years for GBH assault, effectively 5 years imprisonment for the two. But as you heard as we were coming out, their legal representatives trying to argue there for bail and for some concessions. We'll continue to bring you that story on other shows on the channel. But for now, the State Capture Commission of Inquiry continuing to hear the Free State asbestos-related evidence from Director of Blackhead Consulting, Edwin Sodi. Let's go there live, and I imagine it's goodbye from the agenda. Thanks for watching.
People's images as well. So we are cooperating. The information is there, but we just wanted to put that to